Hi, and welcome to From the Ground Up. I'm Karol Weyman with Outdoor Coffee Shop, and I am greeted today with Trent Cotney from Adams and Reese, who is a familiar face in the coffee shops. He's really participated and been a partner and an influencer for all the coffee shops. But I know it's, as a new coffee shop, Outdoor Coffee Shop, we'd love you to introduce yourself.
Sure. My name's Trent Cotney. I'm a partner and construction team leader at Adams and Reese. Adams and Reese is a national law firm. We got 20 offices, almost 400 lawyers, and I've been practicing for almost 30 years in this space. So looking forward to our discussion today.
Yes, definitely. I think today we're really going to give an overview of all the different, not all of them, but some of the different parts of your expertise that pertain to outdoor space and contractors, et cetera. And then I think, we're definitely going to deep dive into some webinars later on in the year. But just to get the ball rolling, I think that agronomics and is one of our segments, we were curious to know what is one of the bigger challenges in structuring vegetation and plant management contracts.
Yeah, they can be very challenging. And a lot of times we'll see whether it's private or it's public work, bid work, scope creep and vague deliverables are always one of the biggest issues. So what I mean by that is where you have scope that doesn't clearly identify, rights of way. It doesn't talk about, trim cycles or the specific species of vegetation that might be needed, clearance distances, all those types of things. So you end up in change order battles. That's a big issue. The regulatory overlays. So oftentimes you've got, local, state, and federal environmental laws that deal with everything from nesting rights to of certain animals to waterways and herbicide rules. Weather is obviously a big issue. Access and permitting. What else? Quality standards can be a big issue. Trim to spec is often sometimes what I see in scope, but that can be meaningless, unless you really dive down into it and you have a manual or photos or utility spec sheets or something like that. And there's other things like damage. Who's responsible for in progress planning? Is it the landscaper or contractor, or is it the owner? Overspray. If you're assigned, let's say you're assigned algae growth removal in a lake or a pond, you have to deal with all kinds of issues with regard to overspray and its impact. There's just a lot of different things, a lot of moving parts, and navigating all that can be a challenge.
Yes, it sounds like it. I mean, it's vast. I'm sure you have standard contracts for different things, but what are some mistakes in some of these contracts that lead to financial loss, disputes, et cetera?
Yeah, the biggest thing is underpricing, misbid. Um, Typically, if you end up in a situation where you've gone to contract and there's a weather hold or there's a shutdown because of utilities or whatever it might be, factoring that into your bid or your contract is something that's really important. Insurance gaps are another big issue. So oftentimes, I see, landscapers and outdoor contractors not have sufficient pollution liability coverage. The other question is, and I kind of mentioned this before, what happens to in progress work? So let's say you started work and then there's a big storm. Is there the equivalent of builder's risk? That's always an issue. Uh, One other thing that I see, especially on private work, is where the payment terms aren't necessarily aligned with production. So the milestones might be mismatched and don't necessarily, mimic what the infield progress is. So making sure that you've really thought about that, making sure that you have measurable specifications, and a clear change order pathway. Because as we know, in any construction project, you're going to have a change or an extra. I can't think of many that haven't had one. So, making sure that's streamlined and easy to understand is important.
Yeah, it sounds like there should be contingencies in there to make sure that that happens. I think that's, um, it seems very vast, the amount of things that could go wrong on natural property, just with weather, with, just everything that comes with the outdoor space. And so I think that's really interesting. Switching gears a little bit, what challenges do contractors face in staying compliant with OSHA heat illness rules? Since they're outside, it's hot in a lot of areas.
Yeah, so a couple of different things here. Keep in mind that OSHA has roughly 26 state plans, and the federal plan. The state plans can be more stringent than the federal plan; it just can't be less. So there are some states, such as California, which is a state plan and already has an OSHA heat injury and illness rule. And currently, under the federal government, they are in the process of promulgating a new OSHA rule, heat injury and illness rule. Been on the front lines of that, served in a lot of different stakeholder meetings and other meetings related to it. This administration may ultimately end up rolling it back, but regardless of whether that rule comes to fruition or not, every employer out there has a duty to keep their employees free from recognized hazards. And historically, heat rule or no heat rule, heat is a recognized hazard. So one of the things that there's really three key things that I like to see. One is consistent record keeping. So you're tracking your hydration. Not only do you have water on site, but you also have electrolytes. We've had some OSHA related injuries because of cramping. The other thing that you want is you want to make sure that you've got supervisor training to identify signs of heat stress early and to stop work. And then the other thing is you need an emergency response plan. If you've got heat injury or illness, you need to make sure that you've got a standard operating procedure to deal with that kind of stuff. It is a big issue, and you'd be surprised. A lot of times we see heat injury and illness claims in places where it's really not that hot, but it's hot for that area. So, for example, if you're working in Minnesota and you have a 90-degree day, that's a lot different than if you're working in Florida on a 90-degree day. You're used to the weather in Florida, or you should be, but in Minnesota you might not be. So having all that, making sure that you document is always key, and track that in your safety manual and your subsequent toolbox talks.
Wow, yeah, those sound like great practical steps to make sure that you're ensuring that the workers are safe. Um, I know that there's protection, the PPE. What how do you ensure that the crews have that and are using it?
Sure. So the first thing is it's PPE, personal protective equipment, is specific by task. So typically with landscaping and outdoor work, you want cut resistant gloves, you want eye and face protection, chainsaw chaps, hearing protection, obviously high vis, chemical resistant and HAZCOM for herbicides. The other thing is issue and fit. You need to make sure that you've got document issuance on fit testing for respirators, replacement intervals, all that kind of stuff. I like to see a supervisor checklist where basically you've got sort of a self-serving PPE to-do list, so that you make sure that all of your crew has everything that they need before they leave the yard and get on site. And the key thing is make it easy. PPE should be staged where the work starts. Focus on, comfort, what I call comfort options, cooling hard hat liners, vented eyewear, anything that's compliant but makes your life better. And enforcement is key. Progressive discipline that goes from oral reprimand to termination if you're not following it, because all it takes is one accident, and that's a big issue.
Right. And I've seen on construction sites where they give incentives and rewards for, how many safety days they have, they're able to kind of, I think at this stage in the game, no one wants to fall ill on a site. Everyone wants to be able to work. And, as a team, it hurts the team when someone is not able to, be there or be able to perform their duties. So I've always found that, sometimes it helps to have just incentives to make sure that you are following all the rules and getting rewards for that. I'm sure that you've seen that too.
Yeah, it's a good point, and navigating that, there's also some legal nuances there. So OSHA, regardless of whether it's a state plan or a federal plan, is looking for discipline for violations, but it's also looking for retraining. So if you come out onto a job site and you see that your crew doesn't have the proper eyewear on, then you should discipline them pursuant to your disciplinary policy and your safety manual. But you should also bring them in and retrain them on that, and then make sure you have a piece of paper that says retraining on, how to properly wear and, put on, fit test for PPE, all that kind of stuff, and then have each employee sign off on it. Be careful with the economic incentives, because we have had a few cases where OSHA has said that if you are doing anything more than an attaboy or a free lunch or even the occasional gift card, that you could be economically disincentivizing crew members to report safety, because they're more concerned about getting the money than they are identifying what safety issues are. You can always incentivize financially the reporting of safety violations. You just have to be real careful about how you incentivize crews if they are safe, if that makes sense.
Oh, that does. That's a really good point. I know people can be competitive to make sure that different job sites, they want to win, so I think that's a really great point to be made. And I think OSHA's definitely on it, because they've probably seen it quite a bit. Again, we're going to switch gears a little bit to the differences between and the risks between 1099s and W-2s for classifications.
Yeah. So what this deals with is what's known as misclassification, and typically W-2 means that they're your employee. You're doing withholding, you're doing payroll tax, you're paying FICA, you're doing all that great stuff. 1099 means you're just striking a check to somebody, right? It's they're in charge of their own withholding, typically a subcontractor or sub crew. So there are a lot of potential issues there, and typically what any government agency is going to look for is control versus independence. So if you set the schedule, the methods, the tools, the supervision, that looks more like they're a W-2, right? If they wear your branding and your gear, then again that looks more like they're your employee rather than 1099. If they only work for you, they don't work for anybody else, they don't advertise, they don't market, there's nothing that says, hey, I'm your employee more than that, right? So when you end up in a situation like that, what is the potential ramification? So the ramifications for misclassification is you could end up owing payroll tax on 1099s if you didn't properly classify them. Okay, and that's a big deal. We've all seen immigration enforcement here lately. You're only required to maintain I-9s on W-2s. But if for some reason it's deemed that you misclassified a bunch of 1099s and they should have been W-2s, and you don't have I-9s on them, then you could potentially have an issue. Now, side note, you don't ever want to ask a 1099 for an I-9, because you could face a discrimination claim. What I'm talking about is if for some reason a government agency looks at it and says, these people are really your employees, you're just not paying them right. In that instance, you may have that. And then OSHA is a big risk too. So under the multi-employer site doctrine, OSHA says that a prime landscaper can be responsible for a sub-landscaper's bad acts if they are deemed a controlling contractor on site, which means if they have control over that entity's safety, then they are as much liable as the sub. So maintaining that independence and maintaining that distance is an important thing for purposes of trying to avoid that liability. It's a complex issue. There are a lot of moving parts, but this is always something that we have to kind of face in construction.
So how do employers avoid, the risk of misclassifying?
Start with strong contract documents. So, your master subcontract agreement should have a variety of self-serving statements. Do they win the day? No, but they get you in the game, right? So what happens, I can draft the most brilliant contract you've ever seen, but if you're doing something different in the field, it doesn't matter. So, having self-serving statements like, this is an independent contractor, you agree you're going to abide by all OSHA rules, that you're 100% responsible for your own safety, that's great. It gets you in the game, right? The next thing is, create that layer of independence. If your subs are wearing your branding, I'd avoid doing that. I understand the marketing and branding component, but from a risk mitigation standpoint, it's bad, right? So I always tell everybody, if you did everything I told you to, you'd probably be out of business. So you'd have to weigh that. But there's nothing that says more that I'm your employee than wearing gear that has your name on it. The other thing is the more your subs look like a business, the better. So if they are working for other people, that's a good thing. If they do have their own tools and equipment, that's a great thing. If they are engaged in their own marketing, great, right? But even if they don't have their own PPE and you need to provide it, the best way to do it is to set up either, do a lease agreement or set off of their pay, or set up a separate distributor account in their name. So you're still maintaining that independence. That's different than saying, hey, here's the PPE you should use for this project. So it starts with the contract, and then it requires operational excellence to maintain that true independence and avoid as much as you can looking like they're your employees.
Yeah, that's great advice. That's perfect. So what contract provisions are essential to protect a contractor's business?
Yeah, probably the most important is a price acceleration provision, which says that in the event that any line item goes up by more than X percent, I usually put 5%, that you're entitled to an adjustment of the contract. And typically, if you're sourcing vegetation, the price can go up based on ship and freight, or it can go up based on rarity. If you're sourcing tonnage, maybe for a stone or fill dirt, that can expand and contract depending on gas prices. So having that in is a really important thing. The other thing is accounting for known problems. So specific provisions that say that in the event that damage occurs during the course of construction prior to owner acceptance, because of weather or something that is not your responsibility, that is not something that you need to cover, and that the owner will obtain the requisite insurance or deal with it. Identifying how long you are going to replace dead vegetation, and watering requirements, monitoring what happens out there during watering after you spread grass seed or vegetation. All that is real important. um, Understanding site conditions. So to the extent that the owner is providing you with information, whether it be soil borings or other things like that, you need some self-serving provisions that say that you're entitled to rely on that, and to the extent that anything is contrary to that you're entitled to an extra. And then, of course, I wouldn't be a lawyer if I didn't say you need good dispute resolution clauses, right? You need to make sure that you've got a streamlined process. Nobody likes lawyers, including myself, except for the good folks at Adams and Reese, in case they're listening. But I would, suggest that you're doing your best to try to resolve things before you have to end up in court. So I prefer, principal to principal negotiation, mediation, which gives you an opportunity to potentially resolve it. Then you go to, maybe arbitration. Make sure you're accounting for attorney's fees. You don't want to be throwing good money after bad. All these things are just a handful of the dozens upon dozens of provisions that normally I like to see in these types of contracts.
Right. And no one wants to see it, on either side go to arbitration or to go to court. It seems like that's a big lose. So setting up these contracts and the clauses to prevent disputes is key. So that's very, very important. And thank you for addressing that. So with all these things combined with, vegetation management, heat regulations, the OSHA and PPE hiring, they all connect to build safer and more sustainable contracting business. And how do you put it all together?
Yeah, there's a lot of different things that you want to look at. Vegetation management is key, as is water management. It is an art. Understanding, the impact of water flow on a project is critical. So what I found is what's measured is managed, and you document your specs, you reduce rework and damage claims the more specific you can be at the onset. The other thing that I think is useful, not to go back to contracts, but really it all starts there. It's aligning price with risk, right? You've got provisions that allow you to suspend work in the event that you don't get paid. You've got notice requirements where written notice has to be required in the event that there's an issue. And if it's not, then the owner waives that claim. All of these types of things are critically important. Once you combine, strong contracts with, safety and, operational excellence, you're going to have fewer claims, fewer incidents. You're going to have a lot cleaner documentation, faster pay, and then hopefully you're going to make more money at the end. Oftentimes, when I talk to whether it's somebody in landscaping or someone that's constructing outdoor kitchens, whatever it might be, there tends to be this focus on top line sales, right? But really, the difference between top line and your bottom line is risk mitigation, right? If you're throwing money away paying lawyers or paying fines to OSHA or whatever else, you're reducing your bottom line. So what I want our listeners to do is to have a holistic view of risk mitigation and realize that the goal is always to be proactive rather than reactive.
Right. I mean, you want a project, but if there's more headaches or there's more issues because of who you're working with, sometimes it's just not worth it too. And if they're always going to see a problem, they're not going to necessarily be a right fit. So it's about the integrity of each company trying to work together to make sure that the end goal is to have a great project. And I mean, I think there's give and take there too. With the years that you've had in construction, I'm sure you've seen tons of things that, two different companies would have made it work and they could have resolved it very quickly. And then there's two companies that go head to head and, it's a big issue. So I think it's good to know who your partners are when you're working in that realm too.
Right. I always joke around. Nobody ever calls me with good news, right? I don't ever get that call. Saying, hey, Trent, let me tell you how much money I made on this project, right? That's not the kind of calls I get, right? Which is
No,
is a
right.
good thing for me because I know what the issues are, and that's why, what I'm telling our listeners now is based on real world experience. It's based on the disputes that I've had to deal with, the contracts I've had to review. I have, the benefit of hindsight, because all I see is the problems, and ultimately I'm tasked with trying to figure out how to fix them. So I can tell you that the majority of legal issues that you will face, I'd say 90% of them could be resolved with better business operations, right? If you had better standard operating procedures, better contracts, better safety procedures, all these types of things, then you don't have to hire lawyers, right? You can take that money and go to Aruba or something. So that's the goal here is be thinking about how can I shore up, my key documents that I need in order to protect myself and make sure that I'm safe moving forward.
Yeah, that's great advice, and that's really important business sense. And it helps not to have business disputes in order to grow your business too. So making sure your standard operating procedures are set. And I even know someone we could talk to about that. So we can have another webinar for that. In fact, we can have a webinar for every to do a deep dive on all the things that we talked about, because everything you've talked about is critical to the success of businesses all around. So we welcome you back again, and share some more detailed. Is there anything you want to say in closing?
No, I think it is the majority of problems that I see on these types of projects result from not not responding quickly enough. So there's this tendency to kind of put your head in the sand, try to handle everything, with oral communications, and customer service, which you should, but the party with the best paper wins the day in disputes. So the goal is an ounce of prevention is worth a pound of cure. Respond aggressively. If it's good for you, put it in writing. If it's bad for you, pick up the phone. And if you do that, you're going to at least mitigate your problems. So that's what I would recommend. And, obviously the more you can do, the better. So.
Well, great. Yeah. Well, I appreciate your time. I know that there's so much to dig into, so I appreciate that. And so this will wrap up our session today with Trent Cotney. Valuable information, and I hope everyone gets a chance to go outside and smell the flowers today. Take care.